I'm suing one of the most powerful companies in the world, and I'm just one person.
I understood what gaslighting meant. I understood what the term meant, but I've never experienced it like I have these 8 years.
We all make mistakes, but I feel like my rights were violated by what they've done.
You have a corporate polluter that, at the end of the day, claims they care about the local environment and the community, but is that reflective of their actions? No.
And I don't think that they were anticipating the public justice was going to come in and argue this.
Every day, corporations and governmental actors abuse their power and cause harm to millions of Americans across this country. And often that harm is not in a way that grabs the headlines, but has real and lasting impacts on our communities. Those fights are the public justice fights. Ending forced arbitration is a central, almost a founding pillar of public justice's work. We've been working for decades to make sure that workers, consumers, anyone with a claim can have their day in court.
I started at TikTok in late 2019. I was there almost for 3 years. I was fired in September of 2022, and it was devastating. Things suddenly turned from being this exceptional performer to being so extremely micromanaged, abusively micromanaged, and I didn't understand why.
Katie was undermined by some of her managers. She was subjected to sexual harassment at an off-campus event, and the company didn't support her or respond to her or properly investigate and ensure that she was kept safe.
It was so upsetting because I was there to work and I had to leave. And it really set me back and it made me feel so uncomfortable. I realized that I may need to take legal action. I didn't even know what that meant. I just knew that I wanted it to stop, and I knew that what was happening to me was wrong.
Katie brought her suit in February of 2024, and then TikTok sought to compel arbitration of her claims, meaning they sought to take her claims out of court and put them in front of a private arbitrator. And the district court ruled in January of 2025 that they couldn't do that because of a recent statute called the Ending Forced Arbitration and Sexual Assault and Sexual Harassment Act. But TikTok sought to appeal that case.
In this case, TikTok is trying to get around the EFAA in a few different ways. Most glaringly, I would say, is that they're saying that this isn't sexual harassment at all, and arguing that sexual harassment means only, sexual advances or sexual comments or lewd comments, and not a pattern of gender-based abuse, which is the well-established meaning of sexual harassment is in the law.
My attorney at Wigdor reached out and told me that public justice wanted to be a part of my lawsuit, be a part of this appeal against forced arbitration. I cannot tell you how grateful I was to know that.
This is one of the first cases about the meaning of the EFAA to go in front of the courts of appeals around the country.
So it's really important that in cases like Katie's, we're able to get courts to interpret that statute broadly to protect the most employees and consumers and anyone else who might be able to benefit from it.
Modern landfill is a great example of the power of a citizen suit, which is a tool that's uniquely and really expertly wielded by our environmental enforcement project.
Our organization operates within an 8,500 square mile territory. Right now we're in Wrightsville, Pennsylvania.
The river keepers across the country are the frontline sort of defense, if you will, to make sure that facilities like Modern Landfill are adhering to their permits.
We're dealing with a lot of impaired waterways all around us, and it's a big job to take impaired waterways and ultimately get them clean again. But in this case, for Modern Landfill, they had control over that. They had to get sued to clean up their act.
Modern Landfill got a permit in 2017 from Pennsylvania, and this permit regulated the discharges from their wastewater treatment system at the Modern Landfill facility. And so Modern Landfill, you can imagine, creates a huge amount of leachate, pollution from the decomposition of all that trash, garbage, refuse, and everything else that goes in there. That leachate gets collected and then ostensibly treated in a wastewater treatment system, then is discharged to Croix Creek. They became pretty obvious early on that they couldn't meet those effluent limitations. And so what happens? They violate their permit, and they violate the permit pretty consistently.
Crites Creek is the stream that runs right by our property. Ted came to me knowing where I lived and grabbed this piece of quartz out of the gravel in the bottom of the stream. And when I picked it up, the half of it that was exposed to the water was orange. The half of it that was still in the sediment in the gravel was white.
Heard from residents and neighbors, I've seen it myself, with my own eyes, the lack of wildlife, the lack of aquatic species.
The kids that live in our community go to Crites Creek Elementary. They should be able to safely go, hop in that stream and look for critters.
But when you sue them in federal court, they have to come up and say, here's our answer. Here the answer was essentially, yeah, we violated our permit 419 times. Obviously this company didn't think that they should be liable for what happened, but nonetheless, the federal district judge disagreed.
I can't say enough good things about public justice and about Jim Hecker and his team.
This case wouldn't have been possible without the legal acumen of Jim Hecker and Steve Harvey. They were able to put together both a powerful summary judgment motion that prevailed, along with an incredibly powerful demonstration at trial that we anticipate receiving a very favorable verdict from the judge in terms of what that civil penalty should be.
It's been a privilege for me and for the organization to be part of it.
Our right to hug cases at Public Justice are about fighting corporations and governmental actors by extension that are not just profiting off of people, but profiting off of people who have the fewest resources in our society.
We live here in Denver, Colorado. We really like to play any activities outside, play ball, soccer. I was incarcerated fighting my charge, which they upped my bond so high, ridiculous high, that I couldn't afford to get out.
So the plaintiffs in this case are not incarcerated people, right? It's a 6-year-old, a 4-year-old, a 9-year-old, and 2 moms. When we incarcerate people, we aren't doing that in a vacuum. People are connected. And so when you incarcerate a parent, you are dramatically impacting the children in their lives, their co-parent, if they have one, their parents, this whole web of people are totally destabilized by that separation.
HomeWave, this company that's in Adams County, they right now are the provider for phone calls, video calls, and essentially have a complete monopoly over communications with families inside and outside of the facility. The jail and the private company make much more money if families are only able to communicate through paid video and phone calls versus actual in-person visits with each other.
They really were upset because I missed holidays and birthdays are special, and even to hug him on that day would have meant a lot for me. That's why I joined the team, for my family and for my loved ones.
We're hopeful that the Court of Appeals and the Supreme Court will focus on what we think the trial court really got right, which is that she made this finding that children are irreparably harmed by this kind of separation.
What gives me hope is definitely working with families.
Our Student Civil Rights Project fights on behalf of students and student athletes who have been discriminated against, sexually assaulted, sexually harassed, really anyone facing conditions in their schooling that make it so that they can't be who they are and live their life to their fullest.
Snyder Hill versus The Ohio State University is a case about a powerful institution that facilitated a serial sexual predator, Dr. Richard Strauss, from the late 70s to the late 1990s. It also covered up that abuse for 4 decades, and then it tried to evade responsibility for the massive harm that it caused to countless students and others.
So I went to student health in 1995, I think that it was, because I had a lump on my chest, and somebody said that you need to get that checked or whatever. He did, several genital exams and rectal exam without gloves and everything. And I remember that I was like, I'm here for my chest. Now in retrospect, I think that he was probably arousing himself, and he was trying to get me aroused, but he definitely had an erection, and he shoved it into the side of me and held me there while he was like working my chest, asking me all these questions. And so I was just, frozen. I didn't know what to do or say.
And so there is just a bold-faced lie in a letter from the head of Student Health Services to Steve Snyder-Hill, saying that Dr. Strauss had never done anything like this before. And this was in 1995 when this letter was written, and the university had known since 1979 about Strauss's abuse.
And then you find out the scope of this, that this guy's done this to thousands of people, and it's just so gross. And then on top of that, you're like, I wasn't confused, and I knew it back then, and now and it just infuriates you. And that's, I think, my last 8 years of my life is pretty much what it's been.
Title IX itself does not have its own statute of limitations. It borrows the statute of limitations from each state. And in Ohio, the statute of limitations is 2 years from when the injury occurred. That's what's typical. However, in Title IX, you have your own rules for determining when that clock begins to run. Because of the legal strategy that public justice developed to deal with the statute of limitations argument, all of these student survivors were allowed to proceed with their claims. Ultimately, the precedent that we established with our co-counsel in this case has been cited in over 120 cases. So this was an important precedent to establish.
Every single time for the rest of humanity, if somebody tries to sue for Title IX and the school lied, they will quote our case, and that's forever.
We take on the everyday assaults on our rights in ways that make a tangible difference for the millions of Americans and communities all across this country.
I just want to thank Public Justice and Caitlin and all the team, Alexandra.
I honestly, I can't say enough about what I think about public justice.
Public justice has the expertise in these specific areas of the law.
Oh my God, it's amazing. We can't do this work without groups like Public Justice.
That's what we mean by unrigging the system. And that's what we show up at Public Justice every day determined to do.